Today, we're diving deep into the hidden rules of contract law, focusing on something that trips up a lot of people, commercial leases. This is really critical for anyone managing business risk because we're asking a fundamental question. When are you legally required to do something you never actually promised to do in writing? We're talking about implied covenants, the duty of good faith, especially when you have, a percentage lease where the landlord gets a base rent plus a cut of your fails. Here, the silence of the contract can mean everything. It can be freedom or it can be failure. Okay, let's unpack this.
It's a fascinating area because the whole problem is created by the financial structure of the deal itself. That percentage rent component, that's what opens the door to a potential implied obligation. So the very way the rent is designed ends up allocating risk, and it tells the court what the parties probably intended. So our mission today is to analyze the very high legal hurdles for implying a covenant to keep operating a business. We're going to use the landmark case of Stop and Shop Ganem to guide us. We'll break down the rules element by element and really focus on what matters to a court: the minimum rent, the fair rental value, and of course, the intent of the parties.
Let's start at the very beginning then, the bedrock of interpretation. Where do courts even start when they're faced with a so-called unspoken promise? What are the controlling principles for deciding whether a covenant, something the parties just didn't write down, should be forced into a lease?
Well, the initial bar is set extremely high. The general rule is very restrictive. Covenants will not be extended by implication unless that implication is, and this is the key phrase, clear and undoubted. Courts are just incredibly hesitant to rewrite a contract that looks on its face to be complete. The standard really rests on this idea of a justifiable assumption. The promise has to include only those things which a reasonable person in the position of the promisee, so here the landlord, would be justified in thinking were included.
So it's an objective test, not about what someone was secretly hoping for.
Exactly. It's not about wishful thinking. It's about what a reasonable person would have expected based on the words that were actually used, or in this case, not used.
Okay, so the test is objective. How does a court use the contract itself as evidence against implying a term?
That's the first rule of thumb. The omission itself, the fact that they didn't write down a promise to stay open, is seen as compelling evidence that there was no such understanding.
The thinking is, if these are sophisticated parties, they would have put it in if they meant it.
Precisely. Silence equals freedom. And beyond that, any implied term has to reflect, justice, common sense, and the probable intention of the parties. So if the contract already protects the landlord's main risks
through, say, a high minimum rent.
Exactly. If there's a substantial minimum rent, a court is very unlikely to just invent a new obligation on top of that. This is totally different from older cases, like the Smiley case with the brickyard, where basically the entire rent depended on the output.
Right. In that case, the minimum was effectively zero.
Yep.
So the court had to imply the covenant or the contract was worthless.
It was an empty promise otherwise. But if the floor is solid, that implied covenant becomes almost impossible to prove.
Okay, that makes perfect sense. Let's apply this very high bar to a real dispute. Let's analyze Stop and Shop Inc. v. Ganem. First, can you lay out the legally dispositive facts for us?
Sure. So the plaintiff, Stop and Shop, is a big supermarket chain. They leased a space for 13.5 years. And the lease had this very specific two-part rent structure. First, a substantial minimum rental of $22,000 a year. Second, a percentage rent of 1.25% on gross sales. But, and these are big buts, only on sales above a very high threshold of about $1.27 million.
Okay, so it was a high bar to even start paying that percentage.
A very high bar. And there was another condition. Total sales across two of their specific store locations had to exceed $3 million. So what happened was, Stop and Shop paid that minimum rent and taxes every single year, but they only hit the percentage rent trigger in 2 of the early years. Later, they decided, for business reasons, to stop operating the supermarket at that location.
But they kept paying the rent.
They kept paying the $22,000 minimum rent and the taxes faithfully. The landlords then sued, demanding that they had to keep the supermarket open.
And so that brings us to the core legal issue for the court.
Yes. The question was, should the court imply a covenant in this lease that required Stop and Shop to keep running a supermarket for the whole term, even when there was already a substantial minimum rent being paid?
What rule of law did the court apply to answer that? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule that an implied covenant to operate is only justified if the minimum rent is so insufficient that it basically defeats the whole purpose of the lease, or if the circumstances make the implication clear and undoubted. And this breaks down into an analytical test with two key elements that the landlord, the one arguing for the covenant, has to prove. First, the fixed minimum rent must be shown to be nominal or significantly insufficient. And second, the landlord has to show a big disparity between that fixed rent and the property's fair rental value, or FRV. That disparity is what would justify the implication.
Thank you. That seems like a very tough road for the landlords. Now, for the court's elemental analysis, let's walk through this step by step. How did the court apply that first element, the one about the substantiality of the minimum rent?
So the court started, again, by pointing out that the omission of an express promise to operate was powerful evidence. Then they looked at the rent. $22,000. They called it apparently substantial and obviously not nominal.
And they had a reason for that. It wasn't just a guess.
Not at all. They compared it directly to the property's tax base back in 1946, which was only about $3,700. That huge difference, I mean, it was over 5 times the tax base, led the court to infer that the fixed rent plus the tenant's own self-interest in making money was the only assurance the landlord had bargained for.
So since the landlord guaranteed themselves a solid financial floor, the court wouldn't give them more.
That's it. There was no clear and undoubted intent to also require them to stay open.
Hang on, though. $22,000 in the 1940s is a lot of money. Why would the lessors even fight over the percentage rent if they were getting such a good deal? It feels like something is missing, unless the property value just went through the roof.
And that is the absolute key tension in the case. The landlords were essentially arguing, hey, we expected this bonus stream of income, and you closing the store killed that expectation. But the court's focus is on what was guaranteed. Since that floor was substantial, the landlords took on the risk that Stop & Shop's business strategy might change as long as that floor was paid.
Understood. That analysis really weighs against the landlord. So let's move to the crucial second element. The burden of showing a disparity between the fixed rent and the fair rental value.
Right, this is the landlord's last chance, the Hail Mary. The argument is, even if $22,000 seems substantial, maybe it's actually not if the fair market rent for that location, the FRV, was, say, $50,000 a year. If the fixed rent is way below the true market value, that suggests the parties must have been relying on the percentage rent to make up the difference.
Okay, but who has to prove that?
And that's the million-dollar question. The court put the burden of showing this disparity squarely on the landlords. They had to prove what the current FRV was and that their $22,000 was way too low.
And did they?
They failed completely. They brought no evidence of the fair rental value, none. So the court was just left with this apparently substantial $22,000 figure. Without that evidence, the whole argument for an implied covenant just collapses.
Wow. So that puts a huge evidentiary burden on the lessor. They're asking the court to fix their contract because they failed to prove the market value of their own property. It's really a failure of evidence, not a failure of law.
Precisely. It's a huge lesson in both negotiation and litigation. If you want a court to imply a covenant for you, you better come with receipts. You have to prove that the express terms you agreed to are economically insufficient compared to the property's true market value.
So after analyzing both elements, the substantial rent and the landlord's failure to prove disparity, what was the court's final conclusion?
The court concluded there was no basis for implying a covenant to continue operation. Stop & Shop was free to close the store when its sound business judgment told it to. The landlords had accepted the $22,000 floor, and they had to live with the risks that came with it.
Okay, this is where it gets really interesting for me. The landlords tried another angle. They filed a counterclaim arguing that Stop & Shop acted not in good faith because they opened 2 competing stores nearby, which, they claim, siphoned off sales. So does the general duty of good faith and fair dealing stop a business from competing with itself?
Not on these facts, no. The court took a look at that counterclaim. The landlords were basically saying Stop & Shop's motive was to move customers to their other stores where they didn't have to pay percentage rent. But the court's logic was pretty straightforward. Since the lessee was free to stop operations entirely because their $22,000 payment fulfilled their main duty, they were also free to open stores elsewhere based on their business judgment.
So good faith doesn't mean you have to hurt your own business to help your landlord's bonus potential.
Not at all. It doesn't force a company to be unprofitable.
Okay, so when would opening a competing store actually be a breach? When does sound business judgment cross the line into, malice or bad faith?
The line is really drawn based on intent and, crucially, geography. The court did say that a lessee's actions could be stopped if they were done purely out of spite or to inflict harm, like closing the store just to hurt the landlord with no real business reason. But the more realistic scenario involves proximity. The court specifically pointed out that if Stop and Shop had opened a new store adjacent, or nearly so, to the leased property, that might have been a different story.
Why is being right next door so important?
Because opening an adjacent store looks like you're actively cannibalizing the very revenue stream of the property you're leasing. You're taking advantage of the location and customer base you built there and just moving it next door to avoid the percentage rent.
That feels like a more direct attack on the deal itself.
Exactly. It could be seen as a violation of the implied duty not to destroy the potential for percentage rent. But here, the other stores were a half mile to a mile away, so the court saw it as a broad, strategic business decision, not a targeted act of bad faith.
This deep dive really shows how silence in a contract, when it's backed up by a solid minimum payment, can act as a shield for the lessee. The landlord is left holding all the risk on the upside.
That's it. It just reinforces that core principle. Courts are not in the business of rewriting a complete contract for a party who is disappointed that their bonus expectations weren't met.
This gives us some incredibly clear, actionable insights. For anyone listening who might face an issue-spotting question on this, what's the step-by-step diagnostic checklist they should use?
Okay, if we connect all these dots, we can build a really solid 4-step framework for analyzing these implied covenant cases. This will help you figure out who has the burden and when the covenant applies. Step 1. Examine the express terms. First thing you do, does the contract explicitly say they have to stay open? If it doesn't, the starting assumption is there's no such duty. Silence is the lessee's best friend. Step 2. Evaluate the minimum rent. Then you look at the money. Is the fixed rent truly nominal or is it substantial? If it's nominal, like in that old Smiley Brickyard case, the argument for an implied covenant is very strong. The whole deal depends on it. Step 3. Analyze the disparity in burden. Now, if the rent is substantial, like the $22,000 in Stop and Shop, the burden of proof immediately flips to the landlord. They must prove a significant gap between that rent and the property's fair rental value.
And if they don't bring evidence of that FRV,
They lose. If they don't meet that burden, no covenant is implied. End of story. Step 4. Check for malice and proximity. Finally, even if there's no covenant to operate, you always have to check the good faith duty. Was this a legitimate business decision, or was it an act of spite just to cause harm? And specifically, did they open a competing store right next door, effectively destroying the rent stream? If it's a remote location and makes business sense, the good faith duty isn't breached.
that clarity on the shifting burden of proof is probably the most critical takeaway here. The contract's silence was a shield, unless the landlord could prove the floor they agreed to was just too low for the market.
It's the ultimate contractual safety net for a lessee. Pay the floor you agreed to and the risk of lost opportunity above that floor. Well, that risk generally belongs to the landlord.
A final provocative thought for you to explore as you think about the future of this. Imagine a percentage lease with a high minimum rent, say 90% of the fair market value. But the lessee ceases all physical operations and moves their business entirely online, earning 0% rent. Would the lessor have a stronger argument for a breach of good faith, given that the shift to e-commerce kind of changes the whole idea of a competing store and removes the business from the physical location entirely? Something to mull over.